The Constitutional Court could soon give unwed fathers the ability to register the birth of their children. The Centre for Child Law has today been arguing before the Apex Court to get confirmation of an earlier High Court ruling to that effect. Currently, Section 10 of the Births and Deaths Registration Act says that a child of an unmarried couple takes the mother's last name. Let's speak more about this then. I'm joined by Zita Hansungule from the Centre for Child Law at the University of Pretoria. Zita, good to see you. Thank you so much for your time. Let's begin then with the arguments that you've laid out before the Constitutional Court.
Well, essentially, our argument is that Section 10 of the Births and Deaths Registration Act is unconstitutional because it doesn't give unmarried fathers the ability to register the births of their children. So now you will, for example, have single unmarried fathers who do not have the children's mothers in their lives and cannot register the births of those children. Currently, the section only says that a mother can register the birth or the father's details can be on the birth certificate with the mother's consent. So our argument is that this places various barriers in children's lives if the fathers are not able to register the births, and we want this section declared unconstitutional and the section amended.
And there wasn't earlier, as I was saying, a High Court ruling to the effect allowing fathers this right. But now what's going on is that you want the Constitutional Court to confirm that. Why is that important?
Well, how things work is that when a High Court or Supreme Court of Appeal declares legislation unconstitutional, the Constitutional Court always has to confirm that declaration of unconstitutionality because it affects how the law works, it affects the powers of the legislature, and the Constitutional Court then has the final say in how that section is dealt with, whether the court itself makes the changes or whether it is sent to Parliament to make those changes.
One of the questions that springs to mind then, Zita, is why it is that such a law would have remained in place for such a long time in South Africa, where we know that the ideal family structure is not always what many of us live through or experience.
Exactly, and I agree with you. I'm not able to answer for the Department of Home Affairs, but this is the reason we took the matter to court, because we were receiving many queries. So the Center for Child Law, Lawyers for Human Rights, and other organizations received many queries from unmarried fathers over the years. And despite attempts to engage, we didn't get anything out of the department. And we said this has gone on for too long, and a change needs to happen. So this is why we decided to collect as much evidence as we could collect. So we put information together from our clients, from clients of other organizations, to take it before the court to say this has gone on for long enough. Children have become adults and don't have birth certificates. That means they cannot access education, they cannot access social assistance, and they cannot access healthcare. This is a hindrance, a strong hindrance to people's lives.
How have such cases as the ones you lay out now been resolved in the past, where you do find a situation where, yes, you've got a father, the mother is not in the picture for whatever reason, this child needs to be registered for schooling and any other relevant Home Affairs documentation? How have we been dealing with it over the years?
So you will have what we call generational undocumentation. So what we're currently working with is mom or dad doesn't have a birth certificate, meaning that they will struggle to register their child. So you have these generational flows where families and children don't have birth certificates, which is quite unfortunate. What we as a center and other organizations have had to do is to write lawyers' letters to really push for children to have their births registered, those who can approach us. But it got to the point where too many clients were coming in, and we could see that this was a large systemic issue and required a bigger case to cover everybody in the country in similar circumstances.
I'm curious about the implications, if any, for situations where you've got both parents unwed but still in the picture, where the mother is there. Would she then still be the one whose last name is on the child's birth certificate in those situations?
So what Section 10 of the Births and Deaths Registration Act says at the moment is that the child can either have the surname of the mother, and the child can have the surname of the father with the mother's consent, or the child can have the father's details on the birth certificate with the mother's consent. So the mother always has to be involved. This is very problematic for fathers where the mother is deceased, for example, is not able to register her child because she does not have a birth certificate or is not in the child's life.
But if she is in the child's life and she refuses to have the father's name appear on the documentation, does she still have that prevailing right?
So now this is where you would have to have matters going to the children's court. So then this is when a father could say that I would like to have my surname on the child's birth certificate, and these sorts of issues can be raised with the Department of Home Affairs. Matters can be taken to the children's court, so there is processes for that.
Finally then, Zita, let's talk about the court process. When do we expect more movement on this?
Well, what we have asked the Constitutional Court for, firstly, is declaration of unconstitutionality. Once they make that declaration, to send the section back to Parliament so that Parliament can fix the defects. But in the meantime, while Parliament is fixing the defect, we have an interim regime that allows unmarried fathers to register the births of their child. Now, all of this cannot come into effect until the Constitutional Court hands down judgment, and that could take up to maybe between 3 to 6 months.
All right, Zita Hansungule, Senior Project Coordinator at the Center for Child Law. Thank you for your time this afternoon.